Hey, hey! We are going to be looking at oral arguments, which I always love listening to. Sometimes we just jump right into them, but with this one, I think we're going to get some backing context before we jump in. So, we're going to be listening to Michigan Court of Appeals oral arguments. I think that's going to be a good time. This is centering on a case involving two individuals, Derrico Searcy and Darrell Ewing, who are pictured here. They've been for like a decade and a half now, all over the appeals process. And judges have been like, hey, there were issues in the original trial. A new trial's been requested. There were issues with the new trial, though, and on the eve of trial, a dismissal was granted. Like, we just got a lot going on. So rather than trying to give you a quick summary, we're actually going to read a little bit more in depth than we usually do. So getting right into this, you guys, hello, as you come in, please hit that like button. Let's get the background on the case itself, the appeals process that got us here, and why we're ultimately seeing the state ask the Michigan Court of Appeals, please undo the trial court judge's decision dismissing our case. Please undo that decision. We're going to watch them argue that. So the incident and arrest, we're going to go all the way back to 2009. We've got on August 16th, 2009, a shooting occurred on Detroit's west side. So we're in Michigan, resulting in one fatality and multiple injuries. Darrell Ewing and Derrico Devon were identified by law enforcement as suspects in connection with the incident, which was characterized as gang-related. So, common motif over here on this channel in the cases that we talk about. Following the shooting, both men were apprehended. Their arrest would mark the beginning of a lengthy battle. So, yeah, it's going to be a time. So, the case itself. We have J.B. Watson and his girlfriend, Loretta Thomas. They're in Thomas's van, another individual, with Philip Reed and Willie Williams. Reed and Williams were cousins and members of the Knockout Boys or the KOB gang. A turquoise vehicle approached the van. According to prosecution witness Raymond Love, there's a love in this trial, the passenger, who was allegedly Ewing, exits with a handgun, fires multiple shots into this vehicle, and then fled as the driver, who is allegedly Searcy. So it's supposed to be Searcy and Ewing in this car, and Ewing's the one that gets out and shoots at this other vehicle. And they speed away. At the trial, prosecutors argue that Ewing and Searcy were in a rival gang. So we have KOB and we have the Hustle Boys gang. And Ewing and Searcy are apparently, according to the prosecution, part of Hustle Boys. And it's supposed to be this retaliation, this back and forth for a feud that's been going on during this point in time back in 2009. The defense says, well, no, there's actually no direct evidence linking our clients, these co-defendants, to these gangs beyond inferences. But they're ultimately arrested shortly after this incident, I think in December. Yeah, December 29th, 2009. One of the victims dies, so that's why we're getting serious charges here. Another was injured, and then the two other passengers in the vehicle that was shot up were unharmed. So there's a little bit of the case background. The evidence that they relied on, they have Raymond Love's identification, and then cell phone records placing them near the area of the scene. So the trial itself. Ewing had the more serious charges. So he's got first-degree premeditated murder. He's got 3 counts of assault with intent to murder. He's got possession of a firearm during a felony. And Searcy has second-degree murder and 3 counts of assault with intent to murder under this accomplice aiding and abetting theory because he was driving. This was in Wayne County Circuit Court. The judge then was Vonda Evans. I don't think we'll really hear her by name, but if they ever talk about the trial court while we're watching these oral arguments, they're referencing all the way back here to 2010. So Judge Vonda Evans, prosecutors relied on eyewitness testimony, the original trial court, not the trial court with the dismissal. So they rely on witness Love, the testimony. The motive was this gang retaliation, and they have some forensic evidence, like the cell phone location. Defense argued misidentification, that Ewing himself he had an alibi. He was at a family gathering at the time. It couldn't have been him. And there's just no physical evidence. There's a lack of physical evidence tying them to the scene outside of those phone location, putting them in the area. Verdict, they're convicted on all counts. Ewing received life without parole. Searcy got 25 to 50 years for second-degree murder. The first stage of appeals, you guys. So this is a 3-year process right here. Like, this is how long the journey takes. It's the scenic route. Right after trial, the defense files for new trials. They're like, hey, there was juror misconduct. And they get these affidavits from a juror. So Kathleen Francis Burns, she's a juror. She submits an affidavit saying, look, I was going to vote not guilty. I was holding out for not guilty. But the other jurors pressured me. And she ends up saying, and she names as 2 other jurors that are named, Michelle Chesney and Karen James. She says that, hey, in deliberations, they were saying they were outside doing internet research on gangs. So they were over there doing a Google. These 2 jurors, Michelle Chesney and Karen, are out there doing a Google on gangs, gang hierarchies. They looked up Ewing's Facebook, which showed him with guns and captions like Mr. and Mrs. Nasty. And they found the victim's eulogy. Burns said this influenced her to change her vote. So not only was there juror misconduct, but it made the holdout that could have changed the outcome of this trial, the literal verdict, change. They also argue that there is newly discovered evidence. Hey, we've got something that nobody's been able to hear before. So the defense brings in this affidavit from Tyree Washington, who is acclaimed and admitted Hustle Boys gang member. He confesses to the shooting. He says that Ewing and Searcy had nothing to do with it. Prosecutors say, oh, that's just unreliable. He's low ranking. He's trying to take the fall. Like, he wants the credit for it. But they're arguing over this issue. And of course, the defense is saying this is something that the original jury never got to hear. 2013, the decision in this. The convictions are affirmed at this point. So this is at the Court of Appeals level, not the state court. The court ends up saying that this misconduct from the jurors is harmless because the researched info was duplicative of trial evidence. Oh, we heard about some gang evidence, gang testimony at trial. That's not really, it's extraneous. It's the same thing. It overlaps. If the misconduct never happened, there's still this other stuff at trial that would have gotten them to the same conclusion. I think this is illogical because the jurors saying what the other jurors told me is what changed my mind. But this is how they rolled. This was the holding. So they say no new trial or evidentiary hearing was granted. So they didn't get to present this information about Tyree Washington. Extraneous influences were not deemed to create a real and quote real and substantial possibility of affecting the verdict. Michigan Supreme Court denied leave of appeal, so they didn't even want to hear it. Also, this is linked, what we're reading. It's a gamma I put together. If you want to read the full decisions, I've linked, you'll see little links in each section for the main filings. So that's there for your disposal there in the description of this video. Next, so now we're going to 2015, right? So we're like 5 years and change, the habeas proceedings. So they end up filing these habeas petitions, both defendants, in 2015. This is in the Eastern District of Michigan Court, U.S. District Court. They argue Sixth Amendment violations due to the juror misconduct and denial of an evidentiary hearing. So we didn't get to have a critical thing. You didn't even let us be heard. Judge Arthur Tarnow conditionally granted habeas to Ewing, ordering a new trial or release unless an evidentiary hearing was held on the misconduct, with similar relief for Searcy. And then the Sixth Circuit Court affirmed this in 2018. They end up criticizing the State Court of Appeals for assessing prejudice without a hearing and remanded to state court for an evidentiary hearing. So here, these 2 stages right here are basically saying, bro, what are you doing? Why did you do this without even holding a hearing? So they've got to fix that. And the ruling here is linked if you want to go check that out in the description. Now they finally have this evidentiary hearing. So August 26, 2019. It's like a decade later now. They're in Wayne Circuit Court. Burns testified the extraneous gang hierarchy info that was researched by the one juror discredited Washington's confession. So they saying he's a low-ranking member just falling on his sword for higher-ups like Ewing. So they're maintaining that Ewing and Searcy, they still have more control in this gang, and that this directly caused the verdict to change after a deadlock. Ultimate ruling here is the trial court ends up granting new trials. So they finally get to have this evidentiary hearing that they're deprived of, and the judge is like, all right, I'm going to grant you guys new trials. So it seems like that evidentiary hearing was important. Findings included that there was misconduct that deprived them of fair trial rights, although evidence of guilt was not overwhelming, or that evidence of guilt was not overwhelming. We had unreliable witnesses of Raymond Love. There was no physical, evidence linked to Ewing or Searcy. There's also all this other information coming in from juror research, and it's prejudicial and not merely duplicative of what was already introduced on the record at trial. So they're like, yeah, no, to the original trial court's findings. And now this is what is going to be the subject of what we're going to listen to today. So, in 2020, we have more going on. So, the Court of Appeals, they end up affirming this new trial order. So that was appealed in 2020, but it's affirmed. So the state loses there. They reject the prosecution's harmless error claim. They say that the burden shifted to the state, which failed to prove that no prejudice beyond reasonable doubt. The Court of Appeals here also noted new hearing evidence changed prior facts. Michigan Supreme Court didn't even want to hear the state's argument. So now the roles are reversed, right? The state Supreme Court doesn't want to hear the state beg. And then now, what would have been next would be a retrial. So after the state loses this appeal in 2020, to reverse the decision granting a new trial, the next step would be to hold the retrial. And there's delays. There's delays because of COVID. There's delays because the prosecutors are still dealing with this appeal. And then we get to approaching trial, and there's discovery disputes. So we're going to have a retrial. We need to make sure all discovery is in place, especially if we're re-interviewing witnesses or there's stuff that, has come to light since. We've got to make sure all that's turned over. Well, the defense ends up alleging that the prosecution is withholding exculpatory evidence, including Tyree Washington's confession details, and they are incarcerated this whole time. So they ultimately end up making this omnibus motion, hey, we're incarcerated, the conditions are horrible. The public, there's protests, and largely with the help of Voice of Detroit, they're linked in the bottom of this document as well, or you can just go to voiceofdetroit.com. They get a lot of people together, and they're advocating outside. They're they're stuck, they're still incarcerated, their convictions were overturned, they're supposed to have this new trial. Also, there's COVID, so there's bad conditions where they're being held, and then there's COVID making it worse. And what are we doing? You need to get this moving. This is unjust. So there's a lot of vocal outcry about what's going on here. And again, we're approaching, this happened in 2009, and now this is now 2021. For two people who at this point are not convicted of anything. And here they are still. So they end up holding a protest June 6th outside of Kym Worthy's office. She's really one of the reasons we're fighting this. So, her state made the decision to continue appealing and have her state prosecutor go argue in front of the Court of Appeals arguments that we're going to watch in a bit. So, and then let's see. Yes. So this is the motion to dismiss, the big motion to dismiss. Judge Kiefer Cox, he's important because his decision here, he's going to agree to dismiss this case that was pending retrial because the prosecution's sitting on their hands and they're the one causing the unnecessary delays. So defense files these motions to dismiss. They say, look, this is 13 plus years of delays. The state, this misconduct, they're withholding evidence. They suppress this confession. Even though they had the time, they kept fighting. It's not just they weren't even paying attention to this case. They were actively advocating against this case, us having any type of relief, but they weren't turning over stuff. So you're working in the case, but only with a selective lens. The state's argument at a brief look, I'm sure no one's surprised, was we've turned over everything we've got. So there's a link here to their pleading here. Judge Kiefer Cox dismisses all charges without prejudice, which would mean this is 2024. Between 2024 and now, this is March 2026, the state could have refiled and gone for another trial. They could have tried to do the retrial seriously without sitting on their hands. Instead, they're appealing this decision right here from Judge Cox. So he ends up ruling that the prosecution failed to comply with discovery over the course of the last 15 years and that the co-defendants were deprived of due process. He describes this as this is a quote, 15-year pattern of withholding exculpatory evidence. I know that's only a few words, but I think that's pretty scathing. So, and then Ewing and Searcy were released, waiting for this, whatever's going to happen here. In July of 2024, attorney Jarrett Adams announced plans to represent the two of them in civil suits against the responsible parties for wrongful imprisonment. So we're going to see all that. And then here we're going to get into the appeal. So Kym Worthy appeals to the Michigan Court of Appeals. The state is appealing. That's what that means. Arguing that Judge Cox abused discretion, that the dismissal was too severe of a sanction, of a punishment, of an outcome for just little tiny insignificant discovery issues. It's no big deal, but look at this big punishment you're giving the state. The defense brief says, well, actually, it's actually appropriate under Michigan, like criminal procedure rules. I don't know exactly what that stands for, but some statutory code here, given significant possibility of innocence. So now we're going to watch these oral arguments, you guys, and I'm very excited for them because, again, this is the state crossing their fingers and pleading with a court of appeals, please undo the dismissal. So here we go. Closed captions should be available, which is a good thing we didn't watch it when it actually happened because there weren't closed captions available when I pulled this up yesterday. And let's see. And hey, everybody, by the way. Hey, everybody. Yeah, 15-year pattern isn't like, oops, we forgot to do our homework. Yeah.
Here. The Court of Appeals stated that is now in session. The Honorable Brock A. Schwartzel, the Honorable Philip P. Mariani, and presiding, the Honorable Seema G. Patel. All persons having business herein draw near, give attention, and they shall be heard. God save the United States, State of Michigan, and this Honorable Court. Please be seated.
Good morning. Welcome to this session of the Court of Appeals. I am Judge Seema Patel, and I have the pleasure today of sitting with Judge Brock Schwartzel and Judge Phil Mariani. Before we get started, a couple of I guess, housekeeping rules. Has counsel for the first case decided how they want to allot time for argument?
You can assume that the order. Oh, that's the people. Rebuttal.
Okay.
I love the Michigan seal.
I think that did we grant oral argument to Mr. Ewing? You are preserved. Okay. Okay. So because this is a consolidated case, I'm not going to go back and forth. I'm going to have the prosecutor give their argument and then have the defense for both cases give their argument. And I don't know if you've had a conversation of how you want to split up that time between the two of you. It's 30 minutes.
It's because there's two co-defendants.
20 for you, 10 for you. Okay, great. And then you will have time for rebuttal. Thank you very much. We will begin. I'll call the case. Item number 5, docket number 370807 and docket number 370809. People v. Derrico Devon Searcy and people v. Rashard Ewing.
The captions are horrible.
Good morning. May it please the court. Dan Hebel on behalf of the people of the state of Michigan. Now,
let me move the captions so we can see the gallery.
The basics are all in the pleadings. So I'm going to point out some things, but I just want to let the court know anytime you have questions, please, that's why I'm here. Okay. Is to make sure that all the court's questions are answered. This case is not about a discovery violation. And this case is not in compliance with either Brady or Youngblood. And that's why the people are a bit baffled by the case in general, why we're here. Because
You explain why there's not a discovery violation here.
oh, absolutely. The court didn't find a discovery violation. The court found a due process violation. If there was a discovery violation, then we go through the standards of discovery violation, we deal with that. There's a lot of different types of relief that the court could have imposed for a discovery violation, and these escalate. Okay, first off, the people asked for more time. We wanted more time.
But you took that off the table. You revoked your, or you took back your motion to adjourn.
The
This is
people,
going
the
well.
people have been under the understanding.
This is okay. Rate this on a scale of like 1 to 10 on how well this is going for the state so far. We are, with all of that intro, because it was like 3 minutes of intro, we're like a minute into this of actual argument.
That the court was not going to grant it.
That's not an
And-
excuse. I mean, you took it off the table
Mhm.
and didn't make the trial judge actually rule on the motion, and that's on the prosecutor. That's not on the trial judge.
And even so, if the, now, I want to back up and I want to say, we don't want to blend two different cases together. There were problems with the first case. And,
What is the first case?
okay, the first,
I mean, use the names. Ewing or,
oh,
oh, you mean the
my
first case?
apologies. The
The
first
original
trial,
trial.
the
I
first
gotcha.
trial of both
I told you
defendants.
it'd be confusing.
There were problems with it. It got reversed. It got to a new team that had no idea about it. New prosecutors that were going in cold because the old prosecutor retired. And they were trying to get everything together. And they thought they had everything together. And then they were asked for more things, and they didn't necessarily know that those things existed. They found new stuff and they provided it. They were providing right up to the very last day. And quite frankly, if the court found
What?
that not enough stuff, that there needed to be more provided,
Is that timely to hand over discovery stuff up until the very last day? That seems like you had 15 years. Like, unless the thing just came about the night before, why are you turning it over up until the final day?
then
Oh, Lord.
the obvious answer would be to tell the people to provide it and adjourn it. Or even if not, tell the people that
But
they
you
were
asked
limited in
for
what
an
they could
adjournment.
use
And then took it away.
to things that were not in question. But none of these remedies were considered. The court did not.
The court did consider the requested jury instruction though, right? And explained why, in the trial judge's opinion, that jury instruction request was not sufficient.
Mhm.
Okay, so the trial judge did consider lesser alternatives.
The trial judge did consider lesser alternatives, but the trial judge was not approaching this from the point of a discovery violation. And that, if we had been able to argue from the point of a discovery violation, if we had been able to offer other remedies from the approach of a discovery violation, then this is a different conversation that we're having
Counsel,
here.
I mean, what foreclosed you from providing a wider range of options to the court?
The court holding that it's a due process violation. When you have a due
But
process.
did the court limit the arguments you were able to present?
Well, quite frankly, if you look at the transcript, okay, the court stated the problem. We have not a discovery violation. We have a due process violation. Tell me what you think. We objected. We disagreed. We don't believe that there's a due process violation because, quite frankly, it doesn't meet Brady and it doesn't meet Youngblood. And then the defense said, well, yes, there is a due process violation. The court, after framing it as a due process violation, found it was a due process violation. So yeah, our arguments were limited when we come in and the court says, this is what's wrong with your case. You are in violation of due
It's all,
process.
I mean, whether the label is due process or something else, it was all based on discovery. It was
Yes.
all based on questions about discovery. And
Oh.
the prosecution had put on the table potential adjournment, and then almost inexplicably took that off the table. And I don't understand the suggestion, well, the prosecutor.
Almost inexplicably. So this guy is just repeating the same thing he tried to question on earlier. He's like, but no, wait, like you're arguing this. It's not discovery, it's due process, but the due process violations are like umbrellaed over a bunch of different discovery violations that were found. So it's just encompassing of those things. And if you needed more time, you'd ask for an adjournment, but then you rescinded it. So that's your own fault. And he already called this out like 2 minutes ago. And then he says almost inexplicably, like there's no reason for it.
We thought we were going to lose it, and so we just took it off the table. Why, you see trial judges having to make calls all the time. I don't understand why that was taken off the table, but at least an adjournment and a jury instruction was considered during that hearing. And you took the adjournment off. The trial judge explained why the jury instruction wasn't sufficient. Why wasn't it completely reasonable for then the trial judge to say, we're going to dismiss these cases without prejudice? You can bring the claims again, or the charges again. Why wasn't that a reasonable approach to whether it's a due process based on discovery or just discovery violation?
Because any termination of the case is in fact the top sanction that can be imposed. And I understand.
No.
Wouldn't the top sanction be dismissal with prejudice?
Yeah.
Yes, of
So
course.
this is not. So this is not.
But it is.
Excuse me. Yes. This is not the top.
Chet! Just getting demolished.
Violation.
Because any termination of the case is in fact the top sanction that can be imposed. And I understand that.
Wouldn't the top sanction be dismissal with prejudice?
Yes, of
So
course.
this is not. So this is not. The top.
But it is.
Excuse me. Yes. This is not the top remedy that this trial judge could have imposed.
It is absolutely. Now, perhaps I misworded it, but I categorize a dismissal as the top, with, once again, of course, a dismissal with prejudice as even higher penalty. But
And the way this camera, if you guys are not watching, if you're just listening, I think this court has like, I don't know if it's motion activated because I don't know what movement they made, but the way it cuts to the different pans, it's very hysterical to me, the way that this just panned to the 3 panel of judges just sitting there staring when he says, but.
Penalty. But
But the dismissals themselves don't foreclose the refiling of charges.
that is correct. The dismissals do not foreclose the refiling of charges. The issue is, once again, that if this had all been framed as just a discovery issue, if that's what we were discussing, a discovery issue, then things are very different. If we're talking 6.201, okay, there are all kinds of things that we can go to discuss. Yes, there's an adjournment that we could go with. We could go with jury instructions.
Over it.
We could go with limitations on what the prosecutor is allowed to present. We can go with other types of things as provided by the court.
I guess the trouble I'm having, counsel, is it seems like, I mean, I understand the due process argument you're making. But ultimately, the court had a problem that it was trying to solve, right? That involved discovery. And I guess what I don't see is why you couldn't, in the context of that hearing, say, listen, Judge, there's not a due process issue here, and here's why. And if you're looking for other solutions, these are different ways you can handle, a non-constitutional discovery issue. We have this, that, and the other thing, and maybe this also. And it seems like, I guess I'm having trouble seeing why, what the court did here, in the context of the issue that was presented with was an abuse of discretion, just given, the way that it handled and given the arguments that it was actually presented with deciding. And, as, Judge Schwartzel has pointed out, the adjournment issue was there, but then not.
I can't represent the mental workings of the trial prosecutors below.
I think I was more prepared for this stream than this guy was for this role. And I only, like, you guys had recommended, and you just said David Ewing. I don't think anyone mentioned the co-conspirator. The co-defendant. But I feel like I did more prep for this stream, so we could have a backing of what was going on than what we're getting here from the state. That does not inspire confidence.
Or trial counsel in general. The record that we have is the record that we're stuck with. And
So your record sucks.
it would be nice if
Look at the lady's face. I forget her name. If we watch more from them, I'll learn their names.
stuck with.
Watch
And
her. It's real quick.
it would be nice if I could
She's like,
look into the mind, or even if I had a transcription of what happened off the record, with discussions with the defense, with any potential sidebars. All of that would be great. But what we have is a record that is extremely narrowly focused on a single issue.
Even if we were to look at this through a due process lens, due process is a very flexible doctrine. You just have to get the process that's due to you, and it can be, formatted in such a way that it deals with the individual problem. The individual problem here all involve discovery, and so even if you couch this in due process terms, wouldn't one of the remedies that you could have, that the prosecution could have requested is, Your Honor, we just need, if it's a due process problem, we need to give the defendants more process. So let's have an adjournment for 60 days and we'll go back and scour the records again. There's ways that even if the trial court was focused on due process, for you to make these same arguments that you're making here in terms of there was all kinds of options we could have explored. I don't see how the trial court, putting it in terms of due process, somehow foreclosed you from making all those arguments about what could have happened.
When the trial court put it in terms of due process, we got shuffled into the issues of Brady and Youngblood. And
oh no,
this is neither Brady.
We got shuffled. What do you mean? These are like critical.
Brady
Lord.
and Youngblood.
We got shuffled in.
And
oh no.
this is neither Brady nor Youngblood. So, this is something that is endlessly frustrating. The trial court didn't find that anything was exculpatory. Did not find that at all. And the trial court specifically found that there was no bad faith. The prosecutors were doing their best and actually made a record of that.
I understand that there might be frustration with how the issues were presented in the trial court, but as a prosecutor, you knew that there were discovery issues. You knew that there were issues with discovery being produced late or not being produced. And why doesn't this just come down to a fundamental fairness issue? I think one of the things that I'm struggling with is that we have a abuse of discretion standard. What was the abuse of discretion in dismissing the cases without prejudice because of these discovery issues?
Well, the abuse of discretion is using due process, either the Youngblood standard or the Brady standard, and finding that the people were in violation of that without the legal cause to do so.
Those are two very specific issues involving due process. But as Judge Schwartzel intimated a few minutes ago, due process is actually a broader spectrum. And I think that, like, how was this not a example of the trial court weighing the issues in front of it and deciding that in order to preserve the fairness of the process and of the case, to dismiss without prejudice? How does that raise to the abuse of discretion?
There's three evidentiary issues that the court was looking at the time. One was an alleged missing video between the OIC and defendant Ewing's.
We stop there.
Yes.
Is it the case that
A missing video.
the original investigating officer in charge had not been talked with by this group of prosecutors up until the Friday before the trial? Or the Thursday or Friday, I mean, the day or two before the trial was to begin?
I am not certain if they had previous discussions. I know that it was indicated that they did at that point. I don't know if they hadn't, or what the logistical reasons would be why.
Well, wasn't the trial judge's maybe a major concern is that this seems to have been the first time that these prosecutors had talked with the original officer in charge, and that this officer in charge alerted them to the very real possibility that a video existed at one time?
Yes.
And isn't that a fairly
The
concerning
audience is nodding
piece
along.
of-
Look.
Yes.
possibility that a video existed at one time?
Yes.
And isn't that a fairly concerning piece of information to be raised the morning of trial?
Yeah, David, I was thinking, like, it's been a little bit of a minute. You came right in here with the good banter with the 15 years comment. Hope you've been doing well. David says he's got to run, but miss watching these with us live. So we miss you too, David. Sorry you've got to run, but hope you have a good night. And thanks for wishing a good night to us as well. Kim's also in the building, says, where do you find these cases? So what's interesting about this one, it just came up on, like, I did a search for, I don't know what keyword I was using, but just to check on different Court of Appeals updates. And I saw the name Ewing, and I was like, the chat had recommended somebody with the last name Ewing a few weeks ago. And I remember, like, writing it down, and I'm like, I didn't really, like, follow up and look at it. So I went and looked at it and realized that they just had oral arguments, and that's why they were coming up in results for, like, Court of Appeals with recent happenings, because the oral arguments was calendared. So last night I tried to organize what I could on this case, get some backing context, and here we are. And I figured it'd be good because this is the state as the petitioner, right? It's the state that has to ask the Court of Appeals to, like, no, please undo something. Please disagree with this currently standing decision. So good to see you too, Kym, and thank you for being a member for 10 months.
No doubt.
Okay, so
What? No doubt?
morning of training piece of information to be raised the morning of trial.
No doubt.
Okay, so I mean, I know there's two other things and you can talk about them, but just that alone, wouldn't that be sufficient to say, all right, we need to do something? And the prosecution had asked for an adjournment. They no longer want an adjournment. So, okay. Jury instruction is not going to be sufficient. Why is it, as Judge Patel was saying, why is it an abuse of discretion for the judge to say, dismiss the charges without prejudice, get your house in order, and then if there's enough to charge again, refile the charges?
I'm going to answer that in a bifurcated way.
Oh boy.
First is under the auspices of due process. The due process has been defined repeatedly with evidentiary boxes. Okay, there's a question that fits in one box. There's a question that fits in another box. There is no box wherein evidence that is missing
I think he wants to crawl in a
that
box.
is not due to bad faith, that is unknown whether or not it's exculpatory. There is no box that fits into right now.
The faces in the
And
gallery.
I think that's very important because, quite frankly, there could be potential evidence in any case that is unknown what type of evidence it is, and that is not a result of bad faith. That literally could exist in any case. And that's exactly what we had here. We had a video that might be exculpatory or not, and it might exist or not, and it was missing, but not due to bad faith. So as far as due process is concerned, due process doesn't touch that. That is a discovery issue.
All right, so let's just look at it through the lens of a discovery issue.
And through the lens of the discovery issue, the easy thing would be for the judge to say, well, in that case, you can't bring up gang affiliation at all. If there's something that might take gang affiliation off the table,
Affiliation.
okay, and you don't provide that, then gang affiliation is off the table. That is one of many remedies that would have worked.
But the prosecution didn't offer that. And I don't think you can just say, well, it was because it was framed as due process, because the prosecution did offer up the jury instruction.
Mhm.
And the judge said jury instruction is not going to be enough. I don't see why the prosecution, as an alternative during that hearing, could have said, well, Your Honor, we'll take gang affiliation off the table. We will not bring it up during trial. Why was that? I mean, is it just the fact that we've had more time and we've thought about this now? Or
Well,
Would
quite
they have
frankly,
a case without it?
if you look at the transcript, it is short. It is not, let's sit down and brainstorm all the ways we can preserve this case. The judge says the case has a terminal flaw. And then the defense says, I agree. And the people say, we don't agree. And the judge says, yeah, it has a terminal flaw. It was not,
That's hilarious.
there was no discussion really on how to preserve the case. This, when we got to that point, it was, let's put on the record the reasons for the dismissal. It was clear from the outset. The court leading in talked about why it found that there was the due process issue and that it gave both sides a brief opportunity to speak and found the due process issue. So, yeah, we're going to come up with a ton of stuff later because there was no time to come up with a ton of stuff then. It was, this case is being dismissed. Do you have anything to say, counsel? Now, I understand that the court found that there were issues, okay? And quite frankly, we wouldn't be here if it was any issue not rising to the point of a dismissal. If the court had imposed any sanctions or requirements on the prosecutor to either what we are allowed to say, what we are allowed to do, when we are allowed to go forward, what we had to provide, any of that, and we wouldn't be here because
Any of that.
we would have complied. And that was one thing that the court found. The court found that the people were trying to comply with everything.
Counsel, can I just, why not just,
Trying and not finding bad faith, finding that someone was actively doing something and finding that someone wasn't acting in bad faith or not doing something in bad faith isn't really the same thing. I think that's a leap there, unless I can see the actual filing and what he said is word for word what the court found.
then just refile the charges? Help me understand.
Going back to square one and starting again. It's a pain. It wastes judicial resources. It wastes the prosecutor's resources.
15 years.
It resets everything. And quite frankly,
She looks so confused. Like, yes, this wastes time, but you're just realizing that now? He's checking his watch.
It wastes the prosecutor's resources. It resets everything. And quite frankly, we were at the point where trial should have been going shortly. And
Well, but this appeal is certainly delaying that. I mean, if we're talking about, judicial resources, prosecution resources, and delaying trial, one could argue that this appeal has checked all three of those boxes.
yes,
Okay.
Absolutely.
So I'm not sure so do you have anything other than those three boxes to suggest why simply, again, getting your discovery house in order and refiling the charges would not be a more than sufficient option for the people?
there's also the issue of witnesses and them retaining their memory after a longer time. Now, quite frankly, what you pointed out is that this appeal, all appeals take a while. And that is perfectly legitimate. But we also have the duty at the prosecutor's office when we see that there is something that is being mishandled. And we believe that this was mishandled by the circuit court. Now, don't get me wrong, I do not want to suggest that the people have a problem with the circuit court, where the people feel that the circuit court was doing what it felt was right. But dismissal as a base level of sanction, even dismissal without prejudice, is something that will, as a practice, cause intense problems throughout this.
Counselor, you have about 5 minutes of argument left. I don't know if you wanted to reserve anything for a rebuttal.
Yeah, I might as well do that unless there's any other questions that the panel has.
Look at the face of the gallery.
Oh, not for me.
Okay, thank you.
Thank you.
Awkward.
Hi, good morning, judges. Blaise Kearney on behalf of Derrico Searcy. Judge Swartzel, I think you hit the nail on the head when the decision of the trial court here fell within the range of principled outcomes, is that it wasn't the most extreme sanction or remedy that could be offered with the dismissal without prejudice. It wasn't an adjournment. It wasn't a particular curative instruction, one of which was withdrawn, the other which was considered and rejected. And so under the abuse of discretion standard here, the trial court should be affirmed because it wasn't an abuse of discretion for the trial court to dismiss without prejudice the charge in this case. And that's true underneath the rubric of due process, 6.201, or a remedy for a Brady violation. A decade after Mr. Searcy and Mr. Ewing were imprisoned, and only after a new trial had been ordered, it was discovered that the prosecution had withheld a Mirandized confession of the man who was responsible for this murder.
Mirandized confession. What does that mean, chat? Well, who would be aware of something? Who would be aware of this confession or whatever was on the statement if it was Mirandized? It's not just something scribbled on a piece of paper that somebody says they found in a couch cushion. Wow, yeah. Yeah, the chat in unison goes, wow.
In the lead up to the retrial,
This is all in the context of due process discovery. It's not a discovery violation. It's fine. Look at the lady in the back.
defense counsel concerned that the prosecution had additional exculpatory information it had not disclosed. The defense undertook every effort, filed motion after motion, to try to compel what Mr. Searcy was entitled to under our Constitution the federal constitution, and the court rules. And time and again, the prosecution claimed that it had disclosed everything that it was required to for 3 years. And that wasn't true.
So the prosecutor on appeal indicated that the real problem, or at least a real problem, was that the trial court looked at this, at least in part, through the lens of due process rather than just an ordinary discovery violation. It looks like an ordinary discovery violation. I don't know that I see the due process there. Is that something that is concerning for us on appeal, or can we treat this as a decision made with regard to discovery, whether you call it the due process or anything else, and look at it through that lens?
I think both would justify the outcome of affirming the trial court in this situation. As a matter of course in trial court, because you're not citing 6.201 when you're engaging in discussions, almost goes without saying, because we're talking about discovery violations. I think the nature of what happened here is the number and the intensity of the discovery violations accumulated into a due process violation, because the requirements of 6.201, specifically subsection B, largely overlap with the prosecution's due process obligations, that I think the result is justified, whichever lens the court uses to actually look through it.
Is it also fair to say that it was the discussion with the original officer in charge, I think on the Friday before trial, that really kind of pushed this trial judge maybe over the edge a little bit? But as I recall, that discussion had more to do with Mr. Ewing and not your client. Does that matter? Do we have to look at this as, with each individual defendant, or because it was consolidated, do we just look at them as kind of a group?
A couple of things, and this is a little bit of a multifaceted answer, so it's going to take me a second to get there. But it does relate to Mr. Searcy and Mr. Ewing, because the particular piece, and I think this is bigger than just those three pieces of evidence that were discussed sort of at the last minute. There is the Beal-Dotson recording, which is actually, I think, the most important piece of evidence. It's undeniably exculpatory. In this case, the government's theory was that Mr. Searcy and Mr. Ewing committed this murder. The defense theory was that Tyree Washington, the man who confessed under Miranda warnings, and William Beal were the people that committed this murder. This lost tape recorder, recording tapes, contained a statement from William Beal that he was there in describing the murder. So it was diametrically opposed to the government's theory. So that was lost, and what was left was an informal summary generated by, I assume, somebody at the prosecutor's office. It's without attribution, but has a sticky note on top of it that says Theo has the recorder and tapes. Now, Theo refers to the officer in charge. That's Theophilus Williams. And so obviously that would be exculpatory as it relates to Mr. Ewing and to Mr. Searcy. In addition, while Mr. Ewing was requesting the interrogation videos of Theophilus Williams that he had engaged in, during which he says not only the gang affiliation stuff, denied affiliation in this gang, but also said that Theophilus Williams threatened him and made statements to the line of, like, if you don't give up who did this, I'm going to make every effort to make sure you go down for it. That was what was specifically requested. But what Theophilus Williams said in response to the prosecutor is, no, also Mr. Searcy was interrogated. I remember Mr. Searcy being interrogated as well. So Mr. Searcy's interrogation. And so in that way, the interrogation videos, I think the fact that the officer in charge allegedly on that video was making statements that could be amounted as engaging in bad faith conduct to make sure someone who didn't do the crime went down for it would also be admissible in Mr. Searcy's case, in addition to the lost interrogation video of Mr. Searcy specifically. Thank you. Yeah. I think it's important to that the court reject the prosecution's argument that the entirety of due process, that the full rubric of due process and how missing evidence issues are litigated or remedied by the court under due process is cabined exclusively to Brady and Youngblood. The United States Supreme Court nor the Michigan Supreme Court have ever held any such thing. I think it is a flexible standard, and the trial court's core obligation is to ensure that any trial that happens has a degree of fundamental fairness. And so both the Michigan Supreme Court and the United States Supreme Court have described, the due process protections much more broadly than saying this is cabined to Brady and Youngblood. And you don't have to go further than the case of Youngblood itself to actually reach that conclusion, because in Youngblood itself situates itself in a broader in a broader scheme of due process, Justice Rehnquist says that Youngblood is what they call can be loosely called the constitutionally guaranteed access to evidence cases, which comes some from the compulsory process clause, some from the due process clause. And Youngblood is dealing with a very, very specific situation. There are two prerequisites before you get to the bad faith sort of conclusion that Youngblood is famous for. The first of those is that the prosecutors completely complied with Brady in that case. They disclosed everything they were required to disclose. They didn't hide the ball in any way. They didn't make any misrepresentations. The evidence was spoiled. It was biological evidence that couldn't be tested any longer because it hadn't been properly refrigerated.
Oh, wow.
And so the prosecutors were open and honest about everything that happened in a timely manner. That's thing one. Thing two that's prerequisite in Youngblood is that the evidence was only potentially exculpatory. Because it was untested biological evidence, it was an evidentiary black box. No one had any indication whether or not the evidence that they would test would actually result in exonerating the defendant. And so the question the court confronted in Youngblood didn't have anything to do with prosecutorial misrepresentations and had to deal with potentially exculpatory evidence. And the question was the appellate court correct in upholding a dismissal with prejudice under those circumstances? They said no. They said you need evidence of police bad faith if under those circumstances you were going to consider dismissing this case forever. And so I think, you flip to Brady, which by its own terms in the actual text of Brady itself says that the Brady obligation exists irrespective of the good or bad faith of the prosecution. And so neither of these doctrines provide for situations where there are prosecutorial misrepresentations that lead to late or non-disclosed evidence that the defense cannot make use of at the time of the scheduled trial. And that's the situation here. And the idea that prosecutorial misrepresentations are not permitted in the presentation of evidence has existed long before Brady. Brady's a 1963 case. We cite in our brief at page 20, Pyle versus Kansas, Napu versus Illinois, Mooney versus Holohan, all of which related to the prosecution sort of mendaciously presenting evidence at a trial, and that's a violation of due process, because of course it is. A trial court needs to be empowered in some way to remedy issues when the prosecution's misrepresentations have affected the substantial rights and the fundamental fairness of a trial. And so I think the necessary antecedent is if the prosecutor cannot make misrepresentations in the presentation of evidence, it also must be, at least under some circumstances, that the prosecutor cannot make misrepresentations as it relates to the disclosure of evidence that's necessary for the defendants to exercise their substantial rights. And so I think that in our brief, we talk about Valenzuela Bernal. That's a case that Youngblood cites that does this analysis that says, is what happened here, which is not a circumstance the court has seen before, rise to the level of a due process violation that infects the fundamental fairness of the trial.
Hey, counsel, does the constitutional versus non-constitutional characterization of this matter here?
I think it depends on what the court means by matters. If the outcome is the same that this court should affirm, I don't think it matters whether the court finds that the court's finding of general due process violation here was justified, or that under 6.201, the court's finding was justified. I mean, People v. Davey makes it very, very clear that among the rubric of options that the trial court has before it when considering a remedy for a discovery violation includes dismissal of the case without prejudice. And so if the court means that,
I guess, is the format of relief any more appropriate under one characterization than the other?
I mean, I think that, I think the court said due process. I think the court meant due process. I think the transcript of that day, the court was faced with a dilemma, as I think you all had, your honors had indicated during Mr. Hebel's argument, that it had a real dilemma there. It could not have a trial that day that would comport with due process, not when there's still exculpatory evidence that's missing, that would impact the way the trial would go, especially as it relates to the recorder, the recorded statements of William Beale, that we don't have the actual words. We have an unattributed transcript that would be almost impossible to impeach somebody with. And so there wasn't a adjournment request before him. It would be difficult to fashion a curative instruction, and Mr. Hebel suggests they could be prohibited from introducing gang evidence. I don't think that was the main thrust of what the issues were here. But also the issues weren't confined to like whether or not the prosecution would be able to introduce inculpatory evidence, but rather whether or not Mr. Searcy and Mr. Ewing, who, let's be clear, were having witnesses driven from federal prison around the country. They're Wayne County Sheriff's deputies en route to go pick people up in Oklahoma when this happened, would be able to actually make use of that material that was lost or late disclosed in the course of the presentation of their defense. And so, yes, I think under People v. Davey, the court balancing all the interests that were before it landed on one that was, not unlike an adjournment when you think about it. The only side effect is that it doesn't punish Mr. Searcy and Mr. Ewing with continued incarceration.
Well, I mean, we've talked about the issue of timing with opposing counsel, and arguably pursuing this appeal rather than going and seeking to refile very, shortly thereafter, after the dismissal. Maybe that has used up more time. I don't know. Explain to me the process that you understand. Let's say that the prosecution took 60 days and just went back and scoured everything and satisfied themselves, and they believe could satisfy a judge that all the discovery had appropriately been found and could be turned over, and then refiled on day 61. How long would it take for the trial to take place after those charges are filed, assuming we don't have a lot of the pretrial stuff that we've already gone through? A lot of the motions wouldn't have to be re-argued. How far along in the process would it have been if the prosecution had done that, taken that alternative route? It's a guess, I get it, but give me your best guess.
I think that's going to be a function of like what the trial court's docket was looking like. So it's
Wayne County, it's the docket that is there right now.
Yeah, understanding that, I don't practice any longer in the Wayne County trial courts. I do know during this trial that the trial date was set in June of 2023, so it's set 9 months out. And that's the point they had sort of arrived at the final conference. All the motions have been filed, all things of that nature. And so,
So at least a year out from the from the refiling, at least a year.
Correct.
Fair.
But I don't think the result would have necessarily been all that different. The difference is that 60 days, right? So the trial court always is trying to prioritize the oldest cases, the ones that are where people are incarcerated, to go first. And so you're always getting to the end of the line.
If they had to adjourn, presumably it would have been just as difficult to come up with a trial date, because, in terms of just getting the jury and everything. If there was an adjournment, would they have realistically been able to have a trial within 60 days, or would it literally have been in a year?
I think it's more likely, obviously this is a hypothetical, I think it would have been closer to the year. And the reason is that the prosecution endorsed more than 30 witnesses at this trial. The court had set aside 3 weeks. The defense had 50 witnesses on its witness list. Obviously it probably wasn't going to call 50 witnesses, but had written people out from federal prison. The Bureau of Prisons requires a significant runway because it has to physically hand off federal prisoners to the custody of Wayne County Sheriff's deputies, who then have to drive them across the country. And so, getting through the federal red tape to get somebody out of federal prison to testify for the defense can be a significant undertaking.
Well, adjournment would not just have been a delay of a few weeks. It probably would have been a very substantial delay. Is that fair?
I have every reason to suspect that would have been the case. And so I think that it's important to understand that, the trial court's afforded an abuse of discretion standard for discovery violations and these due process determinations, because trial courts are expert and the bulk of their work is facilitating the exchange of information. Almost every single hearing that the court can see from the record in this case was one at which discovery was disclosed. And discussed or not disclosed and argued about, all the way from 2021, there are motions to compel being filed into 2023, and then obviously what happened in 2024. And so, I disagree with Mr. Hebel that this is a very short transcript. The trial court makes very clear in the course of that transcript on page 5, 7, and 12, makes references
at least 12
to,
pages.
this is just the main issues we've been talking about just this past week, is how he discusses it. Once it becomes clear that the prosecution has backtracked on a lot of their previous representations, he sort of wonders aloud. He's like, what does this mean for everything else? in reference to, at that point, this particular trial judge had been litigating these issues for 9 months. He had been requiring the prosecution to file a 24-point status report on what their progress was in discovery that was being updated frequently. And, had been dealing with upwards of, I think, 40 of pretrial motions that had been filed by Mr. Ewing, many of which had to do with discovery. And so I think this was not limited to what happened on March 25th of 2024. It had been ongoing for a long time. And I think all the way back to the initial motion to compel that was filed in November of 2021 about these issues. Another thing I'll disagree with about Mr. Hebel, that Mr. Hebel said, is that this was a case where these brand new prosecutors were dumped into it. They had no idea what was going on. They weren't able, they didn't know what they didn't know functionally. The original trial prosecutor handled this case for the majority of the time that this spent the 3 years leading up to the retrial. So the original trial prosecutor came back for the case and handled it from March of 2021 through sometime in 2023, at which point there was an intermediary prosecutor. And then these prosecutors that sort of were there for the last 9 months came in June, sometime around June of 2023. And so, a lot of the litigation, a lot of the representations that the government's disclosures were complete. They had turned over everything twice. At one point, the trial prosecutor staked her reputation as being a prosecutor in that courthouse for 30 years to vouch for sort of the completeness of her disclosures. And a lot of the discovery litigation had been by the original trial prosecutor. So I think that while the prosecutors were standing in front of the trial judge, had only been on the case for 9 months, and I say only 9 months because the court was clearly very frustrated because they had repeated a lot of those same representations. I think that that also explains that why the trial judge had these comments where he says, well, these prosecutors have, I think said been diligent in trying to run some of these issues to the ground now, albeit in the last couple of weeks, but they had actually made efforts and had actually, said, hey, we got it wrong. Previously, there might be more. So I think that was the trial judge recognizing that these were sort of the folks that actually finally got to the bottom of it. And it wasn't excusing everything that it came before. So I think that the prosecutor's years-long assertions of compliance with discovery obligations only to backtrack at that last moment really caused the loss of Mr. Searcy and Mr. Ewing's ability to make use of the exculpatory value of a lot of the evidence. I mean, one of the identifying witnesses died in this case. And
Was it
others
the
couldn't be
identifying?
impeached, as I discussed, as a result of what had happened. And an additional witness the other identifying witness didn't show for trial. That's also in the March 25th transcript.
Oh.
And so Mr. Searcy and Mr. Ewing were faced with the prospect of having a trial with new exculpatory evidence that they couldn't make use of, where they were never going to be able to cross-examine the identifying eyewitnesses based on the new information that had been disclosed. I think that means that the trial judge correctly found that they could not have a trial that day that would forward with due process. And if the government feels that they could gather all this information, they're welcome to do that. They could have done that during the pendency of the appeal and refiled charges. So I think that the government has not been harmed in any way by what the trial court did, that it didn't reward the government by giving them a windfall of adjourning the case and leading to Mr. Searcy and Mr. Ewing's continued incarceration. So I'd ask the court to affirm because this was not an abuse of discretion.
So it's your belief that they could refile during the pendency of this appeal?
I would say I'm not a huge expert on whether or not that would be proper. I certainly think that we may have something to say about that if it was done at the trial level. But I think I would say at minimum, other than electing to pursue this appeal, they could have just simply refiled the case.
Okay.
Oh, that
Any
part.
questions? Okay, thank you.
Look at his face here in the gallery when he says this. Look,
Simply refile the case.
Any other questions?
he's like, yeah.
Okay, thank you.
Good morning, and may it please the court. I am Raven Lockridge, a law student with the Michigan State Public Defender Clinic, arguing under Michigan Court Rule 8.120. I'm here on behalf of Mr. Ewing, who is joining us in the courtroom today. This case has been ongoing for 15 years without a resolution, and through it all, Mr. Ewing has maintained his innocence. March of 2024, Mr. Ewing finally gets a chance at a fair trial, where Mr. Ewing filed over 40 motions, including motions for evidence to receive evidence that he previously did not get. But yet he was still met with months and months and months of lack of preparation and diligence by the prosecution. The Friday before trial at 12 p.m., as you stated, Your Honor, the prosecutor decided that they want an adjournment, but at the start of trial decided we should actually continue trial and just limit the jury instructions. The court explained that they could have not continued trial this way. It wouldn't have been fair for Mr. Ewing. So
If we look at this as, I don't want to say ordinary discovery violation, but the kind of discovery violations that happen in criminal cases, if we look at it through that lens, is it still appropriate for the trial judge to have dismissed rather than some lesser option, an adjournment, a jury instruction, a foreclosure of bringing up certain topics?
yes, Your Honor, it was appropriate. It would have been appropriate for the judge to dismiss without prejudice under these circumstances.
So why?
Mr. Ewing had been filing motions. He was also in jail at the time that this was going on. The prosecution knew that they needed the judges trusted the prosecutor to get the evidence.
Move it
The
along.
prosecutor knew that they needed to get the evidence. They continued to explain that they did not have the evidence, but yet would come back with evidence that they found in the back of the box or wherever they had it. And during that time, Mr. Ewing was in jail, and the appropriate remedy, balancing the light of the circumstances, was a dismissal without prejudice. And adjournment, which they took off the table, as you stated also in your first questioning to
Run
the
it back.
prosecution.
I like
They
her.
took adjournment off the table and they wanted to continue trial. So he considered the adjournment, he considered the limited instructions that they asked for, and found that those circumstances would have not been proper in this case to continue. So dismissal without prejudice was proper. And we can see this happen in the case People v. Evans that this court decided December of 2025, where it's an unpublished opinion. We couldn't file a supplemental authority because it's unpublished. So the court number is 371196. And in that case, the trial court dismissed the case without prejudice due to the prosecution not having witnesses show up on time after the judge gave them multiple time to find the witnesses and get evidence to bring to the court. And the last time that they told the judge that the witness they were looking for was actually deer hunting. And so they couldn't bring the judge dismissed without prejudice. And this court affirmed a very exact thing. The same thing happened.
Counsel, I'm sorry to interrupt,
No,
but
you're
what was that? What was the nature of the error there? Was it a due process violation? Was it a discovery violation? Just tell me a little bit more about the case.
The court didn't explain that it dismissed based on due process or discovery. It dismissed, but the nature of the conversation was about discovery and having a witness on time and having the evidence discovered in the case. So just like here where the judge never explained, this is a blanket discovery violation. It's clear that the conversation was around witnesses and evidence and discovery, and the fact that the evidence and the witnesses were not available and they did not act diligently to make sure that the evidence and the witnesses were there, they couldn't continue trial. And that was then the trial court's discretion this court held. Further, the court properly exercised discretion when it dismissed without prejudice based on 15 years of remedy, as Mr. Blaze pointed out, counsel for Mr. Searcy pointed out, that it would have been proper because of the exculpatory evidence that Mr. Ewing was deprived. We adopt Mr. Searcy's arguments in full, and I'll be happy to answer any questions. If not, I'll move further.
So this will be a good criminal procedure question for an exam someday. Do you
Oh,
know whether
They love her. They love
prosecution
having
could
this
have
happen.
refiled charges against the defendants during the pendency of this appeal?
From my limited knowledge as a law student, I believe that they could have filed charges during the pendency of this trial. They could have actually, instead of filing the appeal and taking time right in the brief, they could have probably just refiled charges.
But I mean, the
With both.
prosecutor had the right to bring this appeal.
Yes.
And so let's just assume that's what happened. Do you know whether while this appeal is going on, a separate set of charges against the defendants could be brought? It'd be two new cases, but it'd be the same, set of facts and circumstances here. Do you know whether during the pendency of this appeal, those charges could have been rebrought in a separate case, and then we have basically parallel proceedings going on?
Given the fact that they couldn't continue trial with what they had, they could probably have started trial if they got their ducks in a row and refiled charges and also did the appeal. But I'm not sure on that, but I think that would have been right because the judge dismissed without prejudice. Further, this court also should examine a balancing approach that would call for dismissal without prejudice under the Michigan Due Process Clause. Arizona v. Youngblood, as counsel before me has pointed out, that a denial with due process is only available if the defendant can show bad faith based on the prosecutor or the police actions for potentially exculpatory evidence. The dissent in Youngblood pointed out that defendants will receive unfair trials throughout this country because of Youngblood. And as legal scholars have pointed out that only 7 out of 1,675 defendants have ever been able to meet that burden for the federal standard. And the criticism is not alone. Delaware has used a certain balancing test under its constitution, and 10 other states have joined to provide greater protections other than Youngblood. We ask this court to examine whether or not for the first time this is appropriate, as I know that this court cannot overrule Youngblood. That is a question that is already codified because the Supreme Court has decided that. But Mr. Ewing asked this court to examine for the first time whether or not under our due process clause, Youngblood is not the proper standard. And for all those—
Would it be appropriate for us to reach the constitutional issue if we can decide this on the discovery issue?
If you could, this is an alternative argument. Our prior argument is that this case is, the trial court was within its discretion to dismiss under Michigan Court Rule 6.201, and that it was proper to dismiss without prejudice. If the court reaches the Youngblood question and decide that the discovery question is not in no way, shape, or form the way to go, it should look to the Youngblood alternative under our due process clause as an alternative. If not, I don't think that it needs to be reached if the discovery violation question is the answer.
Oh, this looks
Because we can
very
avoid
good.
it under the constitutional avoidance doctrine. Is that,
Yes.
that's the conclusion? All right.
And for all those reasons above, this court shall affirm the trial court decision and dismiss the case without
Look at him.
prejudice. And if the court disagrees, it should remand for further consideration under the proper legal standards. Thank you.
Any questions?
No.
Okay, thank you very much.
Thank you.
Counsel rebuttal?
Yes.
He's like, I'll have you know my
Thank
ducks
you, Your
are
Honors.
in a row.
This court has jurisdiction. And therefore we can't refile. Once this court takes jurisdiction,
He's answering the law.
Um,
He's using his rebuttal to respond to the law school question. He's like, see, I know more than her. Oh, man.
all matters below would be stayed in the expectation that this court will dispose of this case in some manner. And after that, then there's another 56 days for either party to request leave to appeal to the Michigan Supreme Court.
So maybe it's a technical point, but do you know if charges had been refiled, let's say, again, my mythological 60 days were taken and charges were refiled by the prosecution after those 60 days, would the two cases that were dismissed be reopened and restarted, or would these be two brand new cases?
They would be brand new and
Okay.
they would be set on the same track to.
So assuming that, it's your belief that two new cases could not proceed along a parallel path to this appeal, even though, and the practical effect or the practical rationale may not make much sense to keep them parallel, but it's your understanding that because the same facts and circumstances would be involved, even those completely different cases, those would be stayed or somehow paused while this appeal took place.
It would be my understanding that they would have to be, because we're appealing a ruling where the judge dismissed without prejudice as errant. Which means that this case survives. And while this case survives in the Court of Appeals until you decide what to do with it, if we charge again under the same facts and circumstances, and that's double charging, we are in violation of double jeopardy.
I'm not sure it's double jeopardy, but I think you're right. I mean, it seems odd, and maybe I don't mean to waste time going down this. It's just an interesting criminal procedure question.
Absolutely.
What would be the practical timing difference between whether an adjournment had been, like a 60-day adjournment had been granted versus the prosecution refiling after 60 days?
An adjournment would get dealt with much, much faster because once
Why?
again,
Because this trial
Mhm.
sounds like it was going to be a logistical nightmare, and it was going to probably be at least a year and a half out from the adjournment, or not.
I would think it would be within the next few months because when you have an adjournment, the trial courts all try to shift things to get that case on because that is an ongoing case that's on their docket. When you have a brand new case coming from zero, okay, it gets put at the back of the line. All right, it gets put at the back of the line at every single stage. Okay, so we would be talking a significant delay in starting from scratch. So the defense has requested that this court create a new due process rule. And I believe as counsel for Searcy put it, they wanted to create a new rule about the prosecutor being wrong about evidence. And,
Oh, no.
saying, hey, we've turned over everything we have. And then they find evidence and they turn that over, boom, due process violation because prosecutor was wrong about evidence. Yeah, I would have done dozens of due process violations, not intentionally, just because I am not all
Here's Sarah
knowing.
Boone.
And people come to me, oh, hey, did you see this? No, I didn't see that. I've never seen that before in my life. First thing I do, I pick up a phone call defense counsel. Under that rule, I'm now in violation of due process.
Well, I guess, isn't it more, I guess, in that framework, isn't it more about sort of just the situation and how it lands? I mean, if that happens, weeks or months before trial, then maybe it's not the same that it happens the eve of. And that's sort of where you get into the fundamental fairness.
Well, when it's due process, it's either one. If you're arguing that, we're talking discovery violation, prosecutor said I had everything, now he says he doesn't. Okay, that's one thing. But if we're talking like, cheating somebody out of fundamental fairness by calling them late and saying, oh, hey, I have something new. That's not a due process violation.
I guess I'm struggling with if we don't get hung up on the label, because certainly a discovery violation can amount to a due
We're back
process
to struggling.
violation. But if we just say there were some discovery problems here, what is your argument that there was an abuse of discretion when the trial judge picked dismissal without prejudice rather than a lesser option, if we're just looking at this through the lens of discovery?
All right. And that's the crux of this, is whether or not we have the right
After all
result
this
with the
time.
wrong ruling, which, as this court knows, can be affirmed. I know that's not helping my case right now, but that's the question. If we look at this as a purely discovery issue, I want to read from the discovery statute, just very briefly. And that is 6.201J concerning violations says that if the party fails to comply with this rule, the court in its discretion may order the party to provide discovery or permit the inspection of materials not previously disclosed, grant a continuance, prohibit the party from introducing in evidence the material not disclosed, or enter any other such order as it deems is just under the circumstances. So we have a full panoply of ways that the court can address it. The court could have addressed it in a dozen different ways. The court could have said, continuance, yes, there's a continuance. You go back, you find it, you show it to them, you show it to the court, you prove that you've complied. No, this is nothing about the prosecutor getting an adjournment. This is a prosecutor doing it right. Go and do it.
So I presume the argument is, well, by dismissing without prejudice, that's the second highest, could have dismissed it with prejudice,
Yes.
but dismissed without prejudice. How did that prejudice the prosecution in comparison to how the prosecution would have been in prejudice under a lesser option, for example, adjournment?
Adjournment would have been dealt with much shorter. Everything would have been dealt with much quicker, and this case would be going.
So it's really the timing issue.
The timing issue is huge. And the timing issue is a very serious issue.
Counsel, you have about a minute left if you want to have any closing remarks.
Oh, thank you very much. In this particular case, the big flaw that the people see in this was that the other options were not considered because the trial court jumped right to due process
Yeah, this
and
is
from
the
there to
state.
dismissal. Okay. The other options should have been considered, and the other options would have done better for both the defendants and for the people. Thank you very much.
Okay, thank you very much. Thank you both, counsel. That case will be submitted. We are going to take a short 10-minute recess before we continue with the rest of our docket. Thank you very much.
Oh, that was a time. Oh, cool. So, okay, here's the name spelled out again. I should have remembered that there was a slide. So, Seema Patel, Schwartzel, and Mariani. There we go. It was very fun to hear them say Schwartzel. Schwartzel. So, yeah, okay. So, I love a good okay. Guys, that was fun. We need to watch more appeals where it's the state petitioning for something. Because holy moly, it's such a role reversal. Because when it's the other way around, they're like, Your Honor, we think that this, or Your Honors, we think that this was harmless. You know, they haven't met their burden to show that this was, you know, a showing of innocence. They didn't provide this other thing. There was a procedural error. They've already argued this issue before. And that's it. And then they get to go sit back down. This was very, very fun to watch. I think we need to campaign for Hal, for Happily Angry Lawyer, to watch this, and then we all watch it again, but we're watching him watch it. So we can do this again. I'm crazy enough to watch things like 2 or 3 times. Aaron over on X, Adventure Aaron, is pulling these little facial expression clips from the audience. Here's another one she pulled. Here's the wide angle view. The yawn. Hand to the forehead. Like all of them. All of the faces. Live reaction to Hal reacting. Heck yeah. So, oh my gosh, that was good. I mean, that makes me feel optimistic that... I mean, I guess not too optimistic, because right now it would just mean we have to wait on an appeals decision and then feel like the state, if the appeals court's like, no, we're not reversing the dismissal, I feel like the state would be like, okay, well, we're just gonna file new charges and we're gonna go that route and we're gonna bring a new trial. So, not optimistic in that regard. I feel like this is going to continue playing out for years and dragging on and on. We should make this the background of the streams, just like rotating facial expressions from courtrooms. But yeah, so also what I thought was really interesting about this, you know, we kind of went through the procedural background on this case. We got a little bit of the case context and the themes of the issues, like the topics of the issues. Oh, there was withheld evidence. There was a confession. But we didn't really get the specifics, things like a Mirandized confession that they had for 10 years. And the way that we watched the state do their first set of arguments, and then counsel for Searcy gets up and gives us that detail. It's just such a like punch through the door, like, well, here's a really, really critical detail that illustrates exactly why this is a discovery issue. And again, how these discovery issues can deny somebody of their due process rights. We're not turning things over in a timely manner. That's a violation of due process. It impedes my ability to prepare my defense and move forward with my case. And the longer you drag, you're just going to put me in a position that because you didn't turn something over, I would be the one that would have to go ask for an adjournment. It almost seems like gamesmanship. Like, oh, we need an adjournment. Wait, withdraw it. And then turn something over and see if they ask for a continuance because they just got new evidence. And we'll make it look like it's their request. Seems a bit like gamesmanship. Maybe it's just complete incompetence. Who knows? So, yeah, you guys are recommending the Dodge Dude Bros depositions. You know, I love a good deposition. I really love depositions. I thought about, you guys remember that attorney that was like raging out? He ended up losing his license during a deposition. I thought about doing a rewatch of that. It was from a few years ago, but we could run that one back. Watch that one. And that's good because I don't have to read it, so I won't lose my voice. I'll just be reacting. Moses is him and Blackburn should open their law firm together. I don't know, maybe he just knows the case was so, that his argument here is so butt. I don't know. That was rough. Oh boy. Yeah, and James says, I don't know if they would make it past the probable cause hearing. And I mean, maybe if it's like one of those situations where, you know, isn't it like only limited areas will let defense or certain things go present in front of the grand jury? I know like almost nowhere allows it, and I'm just gonna guess that it's not likely that this is one of the areas that would. But I'm not really sure if what we know now about the case and all its issues would be something that would be different in front of the grand jury, unless they be restricted if there's an unavailable witness. Like if there isn't another, like if they're unable to present to the grand jury like a written statement from a witness that's no longer alive, maybe that would be an issue. But I don't know, can they not still present statements? So I feel like there's a good chance it would still get past that stage with no issue, and this would just be another drag of time, and we'd be on the repeat loop over and over and over again. So, and yeah, I think that would be interesting. You know, arraignment, bond arguments. If they do, we're going to call it a round 3. If they go for a round 3, we're going to call it round 3. So I guess it would technically be a round 2 if it's reversed, if they reverse this decision. You know, we'll see. I don't know, you guys. I love watching stuff like this. This one was funny. This one was entertaining. I feel like I got to think about things that are like law school questions because of the little bit of banter with really all parties because of the law student. That was really cool to watch. If you want, if there's a way, if I can find a way that there's an indication where someone with a provisional license is making an argument, an oral argument, I kind of think it'd be cool to like watch those specifically. So if there's a way that we can search and figure that out and filter and like go pull up the oral arguments, that would be so cool to keep watching law students do their thing. So with that being said, you guys, link to Discord, let me get you in here. There is the Discord link in the chat. And then if you want it, you're saying it's about the Foss case. Once you're in the Discord, you'll see a bunch of like community chat tabs as the first list, but then there's a list underneath it called case convos. There is a dedicated Edric Foss case convo thread. So do that. Yeah, Adventure Erin says, she did so well. I've never seen a law student argue before. We don't really get to do that here, even if we're provisionally licensed. Whatever I was reading earlier, we had somewhere it was mentioned. I don't think it was this case, but I'm kind of like losing track of my day. It's been a long day. But someone else, I think it was a different district that said they have a clinic. They have a justice clinic where Oh, I think it was the amici, the amici brief. They gave some background context on some of the amici that were filing, and they're like, oh, they have a justice clinic that helps, law students get experiential practice with the public defender's office. And I think they said one other thing. And I don't remember where that would have been, though. Maybe that was in Texas. I think it was Howard University. So there you go. So 2 times in one day, we heard about programs where I'm assuming experiential means some type of like hands-on practice like this. So I think it's similar. But yeah, super cool. James says, I've seen it more than a few times in federal court. I'd like to keep watching it because I feel like it was easier for me to understand the language she was using. And I'm sure that's to her credit, right? But also a little bit, the justices in response to her were like, hey, oh my gosh, you're a law student. Let's ask a thoughtful question. And I thought that question was cool for someone like myself who isn't really studying law. I'm just picking it up as we go. Thank you guys for hanging out for this stream and watching this. Again, we're going to bug Hal to do a watch on this. I know he's so busy with a bunch of things, but if we hint to him, or Aaron, we could share the screenshots of the facial expressions like these on the screen right now. And this might be enough to convince Jim he should watch this just based on the facial expressions. So there we go, you guys. Thank you so much for all the time you choose to hang and spend with me and the chat. Love you guys a lot. See you guys tomorrow morning. I'm going to try to go live at 10:30 when the judge plans to issue his verdict and whatever findings. I don't know how long that will be, but I think we'll get to hear his reasoning and it won't just be like a guilty, not guilty reading from the jury. So that's for the Cole Goldberg case. So with that being said, see you guys tomorrow morning if you want to hang out or somewhere else out in these streets. Thank you. Bye, guys. What's my new phrase? Enough. Enough is enough. Enough is enough.